Hello and good afternoon. My name is Kimberly, and I'm a paralegal here at the law office of Olu Asekun. Unfortunately, today Dr. Asekun is actually out of the office, so I am going to be here with you this wonderful Wednesday, and I will have him available over the phone to answer all of the questions that come in. Today, we are discussing the L visa, and again, we do this every Wednesday at 12 p.m. noon. That's Central Standard Time. We're here in Dallas, Texas. So thank you so much for joining us. I'm going to go ahead and get Dr. Asekun on the phone right now. Okay. Hello.
Oh, I thought you called me.
I did. We are here on the podcast.
Okay.
Okay. So I have
So am
you.
I live now?
Yes.
Okay. Good afternoon, everybody. Welcome to Dr. Olu Asekun podcast. Unfortunately, I'm not able to appear in person today because of a family engagement. Um, However, I will still be able to answer your questions. Today, we are discussing L status. L status. So if you have questions relating to L status, start sending your questions in. I believe by now you have our numbers, 817 891 449. Kim, can you
Yes, I
say
have
all
them.
the numbers?
Yes. So our numbers are 817-983-4499. And then our other office line is 817 883 4495. It's across the screen right now.
Okay, so start sending your questions in. For those who have questions, start sending your questions in. We'll be discussing L1 today. Okay, so before the questions, I want to tell you that for L1, preliminarily for L status is a kind of status that allows a business owner, somebody who has a business in his or her hometown, in his or her home country, and that business has a branch in the United States that it will be transferring an employee to work in, or if it's a business without a branch in the United States, but they just want to establish a branch, open a new branch in the United States. So the L status will allow the applicant to open the business, and then they will be authorized to work in the United States. Incidentally, for L status, unlike other non-immigrant visa, the spouse is allowed to work. Unlike other non-immigrant visa, I know that for those who are on R1, the spouse on R2 is not able to work. In the case of L status, the spouse who will be on L2S is allowed to work. So this is one of the benefits of the L status. In addition, if the applicant is coming into the U.S. to set up a new branch of the company, the applicant will be authorized. The L1 status will be valid for initial 1 year. That is because the government wants to be sure that the purpose is actually actualized. So they don't want to just give blanket approval. So they expect the company to be set up within the 1 year, and then After that, the applicant can now apply for an extension of the status. So it can be extended in increments of two years for a maximum of 7 years. So the applicant can be on L status for a maximum of 7 years. In addition, L status can also eventually lead to green card. So those are the benefits of L status. But again, especially for those who are coming in to set up a new company, within that 1 year, even before the application is filed, the applicant must identify a viable office where the business will take place. Then within the 1 year, the applicant must show that company is viable and is able to employ someone in managerial or executive position. So those are some of the requirements. The company is not required to engage in international trade, but the company must engage in a normal viable business. That is a business that employ American citizens, a business that is running on day-to-day like any other company, but they are not required to conduct international trade. So those are the benefits of L status. So I want to start answering the question now if questions have started coming in.
Yes, we do have some questions. Actually, we have quite a few. Okay, so the first question that I have is, can I transfer my L1 visa to another company?
Another company in L status?
Yes.
Yes, if you meet the requirements, yes, it is possible if you meet the requirement. But the reason is going to be difficult. It is going to be difficult for the following reason. For L1 status, an applicant must have been working for the employer for at least 1 year before the petition is filed. So if you are working for an L1 status and you want to transfer to another L1 company, it's going to be difficult to meet the 1 year deadline. It's going to be difficult to meet the 1 year deadline. So the 1 year prior employment. So it is possible, but it's going to be difficult because how can you prove you have been working for the employer for 1 year when the record will show that you are actually working for a different company?
Exactly. Okay, so then the next question is, who qualifies as a manager or an executive?
Well, it is the job duties that will determine who qualifies, because it has to be a position where you will have to take decision without waiting for a directive, or where you have to supervise the work of others. I mean, the word manager, the meaning of manager means that you have to be the one managing the office. You have to be the one taking decisions. You have to be the one supervising other employees. You have to be in control. So it cannot be a position that is maybe a clerical position. No, it has to be a position where you can take executive decisions, where you can take decisions without being questioned, where you can commit the company, where you can supervise the work of others. So it is the job duties that determines that. But generally, it has to be a position where you can supervise the work of others, or where you can take executive decisions without recourse to other people.
Okay. So the next question that I have is, can someone come to the United States on a visiting visa while waiting for the completion of their L1A visa?
Yes. L1, there is opportunity to change status from B1, B2, visiting visa, to L1. Yes, you'll be able to do that. But the only challenge with that is that 1 year 1 year thing. So you must have been working for the company for at least 1 year within the last 3 years. So if the applicant meets those requirements and the applicant is in management position or executive position, yes, if the applicant entered the U.S. in a B status, B1 visitor for business or B2 visitor for pleasure, the applicant can always change status to L1. Yes,
Okay.
it's possible.
Okay. And then can someone on the L1A visa be working part-time, or do they have to be working full-time?
No, it has to be full-time because, like I said, that is what you sign up for. That is what you told immigration you want to do. And you have to, like I said, the initial approval, if it is a new company, if you are coming to start a new company, the initial approval is only for 1 year because they want to be sure that you are actually doing what you told them you are coming to do. So you cannot be doing it on part-time. No, it has to be full-time.
Okay. And then the next question that I have, must employers pay L1A workers the current prevailing wages?
Yes, usually the employer must pay at least minimum wage. For the applicant, yes, it must be prevailing wage, but for other employees, it must be at least minimum wage.
Okay.
The employer because for the applicant who is coming to work in an executive position or managerial position, yes, the salary must be prevailing wage. But for other employees working for the company, the minimum requirement is minimum wage.
Okay. And then what visa status is given to the dependents of a holder of an L1 visa?
Yes, I already answered that previously. Yes. For the spouse, the spouse is given L2S. L2S. The S indicates spouse because, like I said, the spouse is authorized to work. So the spouse will get L2S. But the other dependents, if they have children, those ones will be on L2. But those ones are not allowed to work. But the spouse is allowed to work. That is why they separate it by adding that S to it. L2S.
Okay. And then can a business owner get to the U.S. using an L1 visa?
For the business owner to get to the U.S. using L1 visa, that means the L1 petition must have been filed and approved.
Yeah.
And then the applicant must have applied for L1 visa at the embassy. So it means the company must have been set up, the company must have been doing business, the company must have filed the L1 status, and then L1 is approved. So the only way that can be possible is for a company that already have a branch here in the U.S., because it is only the U.S. branch that can file the petition. So the foreign company cannot file L1 status. It is only the branch that is set up here in the U.S. that can file the petition. So if somebody wants to enter the U.S. with an L1 status, the company must have been set up here, or maybe the company can buy another business here. But there must be a U.S. business that submit the petition on behalf of the applicant. Then after the petition is approved, the approval is sent to the embassy, and then the applicant will apply for L1 visa at the embassy. That is the only way an applicant can enter the U.S. with an L status.
Okay. And then someone has asked, what happens if I am fired by my employer, who's the petitioner in this case, while I am on my L1 visa?
Well, L1 is a non-immigrant visa. Every non-immigrant visa is not permanent. That is why they call it non-immigrant, temporary visa. In fact, majority, if not all, majority of the non-immigrant status requires the employee to return to his or her home country at the end of the authorized period. So if the employee is fired, you will either have to go back to your home country or you have to quickly find a way to change your status before you get out of status.
Yes. Okay, let's see. Oh, here's a good question. Can the L1 visa petitioner or the company be a nonprofit organization?
So how is that going to show international trade? How is that going to show connection? Because there has to be a connection. We are talking of a foreign company that is doing business in his or her home country, coming to the U.S. to come and have a branch of his company here. So how is a non-profit going to do that? I don't see how that can be possible.
Okay.
Because it's not just a matter of setting up a company here and then filing for L1. No, it is actually called intercompany transfer. So you have to have a company in your home country that is doing business for at least 3 years, and the applicant must have been doing business must have been working for that company for at least 1 year within the last 3 years. And then it is that company that is coming to set up a branch here in the U.S. So I don't see how a non-profit can do that.
Okay. And then here's a question about the L1B visa. If I have an L1B visa, can I be outsourced to other companies?
Well, that would depend on the nature of the business. It would depend on the nature of the business, and any outsourcing will have to be there will have to be an amended petition filed with USCIS for that to happen. Because usually for L visa, just like every other non-immigrant visa, the job location will have to be provided to USCIS. The employer will have to provide the office location, the job location, the job duties, hours of work, and all of that. So all those information has to be provided to immigration. So if any of those things are changing, and you need the company need to outsource the employee, they will have to file an amended petition. Except if that was initially part of the original petition.
Okay. Let's see. Okay, here's another question about the L1B visa. What if the person with specialized knowledge for the purpose... Wait, hold on. That's not a full question. I'm sorry. Okay. Okay, let me go to the next question. Okay, my old passport has already expired. My visa to travel to the US is still valid, but it's in my expired passport. Do I need to apply for a new visa with my new passport?
No, you just need to apply for a new passport and then attach the old and the new passport together, and you can travel with it. You don't need a new visa.
Okay. Oh, and I think this is what the other question was asking. Here it is. Okay. What is the specialized knowledge required by USCIS for the L1B visa?
I didn't get the question.
It says, what is the specialized knowledge required by USCIS for the L1B visa?
That's not something I can determine.
Yeah.
That would depend on what the company is doing. I mean, let's say the company is an IT company, and then maybe they have some product. Maybe they develop app that can prevent hacking. I mean, the employees who can handle that. Those are the kind of employees with specialized knowledge.
Mm-hmm.
So it depends on the nature of the business. What I'm doing now, legal practice, is a specialized knowledge. It's not everybody that can do it. So if a law office is filing L1, of course they will need somebody with a specialized knowledge, somebody with a law license to do it. So it depends on the nature of the company and what they do. That is what will determine what the specific specialized knowledge will be. But it means that the employee that will be applying for L1B will have some kind of a special skill that they will be providing to the company. So that's what that specialized knowledge means.
Okay. And then the next question.
Let me add this. Let me add this. Even though this one is not included in the status for L1B visa, however, because L1 has some similarities with H1B, for the purpose of H1B, because that is another area where specialty occupation was defined. It was not defined in the case of L1, but borrowing the example from the L1B, specialized knowledge required somebody to have a minimum of 4-year degree. That is for the purpose of H1B. It may not be the case with L1B because, like I said, specialized knowledge may be somebody with some technical skill. Maybe you have the skill to set up or to repair iPhone, for example. So you may not necessarily have a 4-year degree, but you may have this special knowledge. Especially for those who are in IT, many of them do have certifications. They may not have 4-year college in the field, but they do have different kind of certifications. So they may still be qualified as having specialized knowledge. For as long as what they are coming to do is not a clerical job or something, it has to be something that requires some level of expertise.
Okay.
Yeah.
Then the next question is, what if I want an L1 visa, but I am going to work for the U.S. and I'm going to work for the U.S. operation, but will still want to be an employee of the home country company and still be paid from there? They're asking, is that possible?
That would be difficult because if you file L1, L status, if you apply for L status, one of the things you have to prove is proof of ability to pay the employee. So if you are paying the employee from your home country, how does that contribute to the American economy? Because that simply means you will not be paying taxes. It means that you will not be paying into Social Security. That means you will not be paying into Medicare, Medicaid. I mean, that is something that I've not experienced, but I honestly believe that the USCIS will have issue with that because I don't see how that will contribute to the American economy. Yeah.
Okay. And then someone asked, if I am in the U.S. on an L1B visa, do I need to leave the United States to apply for a green card?
For L1, no. If you are in executive or managerial, or if you have the special skill, no. You can do the green card process from here without leaving.
Okay.
But you also have the option of doing consular processing.
Okay. This question is not specific to L visas, but just non-immigrant visas in general. They said, my non-immigrant visa expired before I was able to travel to the U.S. What should I do?
it means you don't have visa. Well, you have to reapply for a new visa. Because the visa is not a document you use in the U.S. It's a document you use when you are outside the U.S. So you have to show it to the airline while still outside the U.S. So if you don't have a valid visa, no airline will bring you here, because if they do, they will be subject to a lot of penalty by the U.S. government. So you have to apply for a new visa.
Okay. And then someone asked if you could explain, why does the L visa not require a labor certification?
Because L visa is a non-immigrant visa. Most non-immigrant visas do not require labor certification. Even for H-1B, the labor certification that is required for H-1B, it does not require the employer to advertise the position. It only requires the employer to apply to the Department of Labor and to also obtain prevailing wage determination. That is all that is required. Employers are not required to advertise position and offer the position to American citizens first before they can hire anyone for a non-immigrant status. Every non-immigrant status is temporary. It's not permanent. It is only permanent employment that labor certification was created to address. It was not created to address temporary employment, because they know it is temporary. So it's not something that the government is concerned about. They are concerned about permanent employment. And that is why for labor certification for green card purpose, that is what is called PAM. Permanent labor certification. So that's why it is called PAM. It is only when an employment is permanent. That is when employer have to go through that procedure. But the only non-permanent labor certification requirement is for H-1B, and again, that one does not require the employer to advertise the position or offer the position to American citizens first. It only requires that the employer apply to the Department of Labor, notify the Department of Labor that they want to hire someone on non-immigrant visa basis, and of course request prevailing wage determination. So that is why all non-immigrant status does not require that.
Okay. Thank you for that. The next question: what documentation should I show to have an L1A visa to open my new office or branch in the U.S.?
You have to show that the business is registered here in the U.S. I mean, you must show certificate of incorporation. You show the articles of incorporation. You show bank account to show that you have the financial needs. You can meet the financial needs of the company. You show that you have an office already. Of course, you have to show the lease, showing that the company is already operating. You show your phone number. You show the resources that you can hire the employee. You also show evidence that the applicant has been. You show evidence that the company is already doing business in your home country for at least 3 years, out of which the applicant has been working for the company in your home country for at least the past, or at least one year out of the preceding 3 years. You show evidence of how you have been paying the employee, or any other evidence to show that this person was actually working for the company in your home country. And then you show what the nature of what the applicant's job duty will be here in the U.S., how many people you will be supervising, what their job duties will be, and all of that. So that is all that is required.
Okay. Someone has asked, does the parent company have to own the affiliate subsidiary or branch 100% for an L1 visa?
Not 100%. If it is not a new company, no. Even if it's a new company, not 100%, but at least substantially. substantially, not 100%, because it depends on how big the company is. I mean, there are some companies that's worth billions, so you don't expect one person to own them. So no, it doesn't have to be 100%. It could be 100%, but it may also not be 100%. It may be, but it has to be substantial to justify sending an employee from abroad.
Okay. And then how much capital is required by the law for a new subsidiary in the U.S.?
Well, the law does not set up a specific amount of capital. Every case is different. It depends on the nature of the job. It depends on the nature of the company. It depends on the nature of the business. It depends on what the employee will be doing. It depends on the prevailing wage in the sector. So it depends on what the company is doing. I mean, for example, a car manufacturing company cannot be set up with 100,000 or 500,000. So that will be something that will be. But that does not mean that other smaller companies cannot be set up with 200,000. So it depends on the nature of the business, what the business, the company is doing, and what the employee will be doing for the business. So it depends on all those things.
Okay. And then
of course, whatever the amount is, you must take into consideration the ability of the company to pay its bills, to pay its expenses. So the company must show that it has sufficient money to pay salaries, has sufficient money to pay rent, to pay utility bills, phone bills, internet bills, all those things, and still be able to pay the applicant they are hiring. And then, of course, the business must be viable. So it's not for you to bring in 100,000, out of the 100,000, maybe the employee is getting paid 70,000, and then maybe you are paying 24,000 a year for the rent. You still have to pay. That's not going to be a viable business, because that business cannot even last for 1 year, for more than 1 year. So that is one of the reasons why for new companies they approve it for initial 1 year, because if they cannot see the viability, they will not extend it. And again, extension is also in increment of 2 years. So they don't, even though you can be on L1 for up to 7 years, they don't give that 7 years at once. So they start with, for a new company, if it is a transfer of an existing company, initial approval will be up to 3 years. But if it is a brand new company, the initial approval is 1 year. So they want to see, is this company viable? In fact, viability is the test by the law. What the law requires is that the company must be viable. So if you have enough money to show that you can pay salary for 1 year, you can pay your rent for 1 year, you can pay all the expenses, you still have to show that the company is viable. So, because if it is not viable, even if they approve you for the initial L1, they will not extend it, because by the time you apply to extend, you have to show that, okay, even though you have succeeded in the last 1 year, you still have to show evidence that you are still able to continue in business.
Yeah, that makes a lot of sense. Someone has also asked, will there be an interview for an L1 visa?
Every visa requires an interview, but change of status here in the U.S. does not require an interview. If you change your status in the U.S., you change to L1, it can be approved without interview. However, they don't issue visa in the U.S. And because they don't issue visa in the U.S., if you have to travel out of the U.S., you will still need to go to the U.S. embassy in the country that you are visiting to apply for L1 visa. Because whatever visa you enter the U.S. with, once you change from that status to L1, that initial visa will no longer be valid. So you will still be required to apply for L1 visa or visa in your current L status. So every non-immigrant visa, in fact, every visa requires interview. So you will still be required to apply for interview, to appear for interview if you want the L1 visa. But if you are doing a change of status from any non-immigrant status to L1 and you do not intend to travel, then you don't need a visa. But if you intend to travel, you will need to get a visa in the L status. And of course, every non-immigrant visa requires an interview at the embassy.
Okay. Let me see what the next question is. Okay. Can I get an L1 visa so that it allows me to be self-employed in the US so I can then close the foreign operation when I arrive?
No, that is not the purpose of L1. Once you close the foreign operation, then there is no longer a intercompany transfer. Because like I said, you are supposed to be coming to the US to establish a branch of your company, not a replacement of your company. You are coming to establish a branch of your company. So you are not coming to replace your company. So if you close down your operation in your home country, then it's not qualified for L1.
Yeah, so it's not like someone who's just moving their company to the United States can do that. That's not the purpose.
Set up a branch. Yeah, that's not the purpose.
Okay. And then what is a blanket L visa petition?
That is when you have multiple employees. I mean, that addresses maybe a big company. Let's say Microsoft, for example. Let's say Microsoft UK or Microsoft South Africa. They want to transfer some employees to the US from South Africa, for example. Maybe they are planning to bring in like 20 employees. So they can file the blanket L visa for all of them using the same form, I-129 petition. Yeah.
Okay. You may have touched on this earlier.
They don't have to be employee specific.
Okay.
They can say that we are bringing in 20 lawyers. They don't have to say, oh, we are bringing in Olu Asekun.
Oh, actually, we have a follow-up on that. What are the requirements for blanket L petitioners?
Yeah, I already said that. It is when you have a big company trying to bring multiple people and they want to just file one petition without listing the specific employee. Maybe we need 20 IT technician from India.
Okay. I believe you may have touched on this earlier too, but someone asked, what is the relationship between L1 visas and foreign trade agreements?
Foreign trade agreement. Are you talking about e-visa? Because I'm not understanding. Because L1 visa is saying that you already have a company in your hometown that is doing business, and you want to establish a branch of your company here. So foreign trade agreement has nothing to do with that. Foreign trade agreement is more like countries that have trade relationship with the U.S. Maybe like NAFTA, North America Free Trade Agreement, where Canadian citizen or Mexican citizen can come into the U.S. to work. but that has nothing to do with L status.
So there's no relationship.
No, there's no relation. It's not part of the requirement
Okay.
that you have a foreign trade agreement.
Okay.
But of course, the area where it may be relevant is if the United States has a trade embargo on your home country, that may affect the ability of getting an L status approved. If there's an embargo, if there's a trade embargo between the United States and your home country, yes, that may have an issue. That may have an impact on the petition.
Okay. Let me see. I think those are all the questions that we've received so far. Let me see. Hold on.
Please send your questions in. If you have additional questions, send it in. It's an opportunity to answer all of them today. Send your question in. We are discussing L1 visa today. We are discussing L status. So send your question in, because I do know that we receive questions individually from the office, and that is why we are addressing L status today.
Let me see. Let me check YouTube. Okay. Oh, here's a question. I believe you answered this, though, that children of L1 visa holders can go to school. I believe that you said yes, they can.
Yes, they can go to school. Yes, they cannot work, but they can go to school. But the spouse can work.
Okay. Okay. And then this is just kind of a blanket question, but about the privileges of holding an L1A visa.
What do you mean by privileges? Or as in advantages?
Yeah, I think so. They said, like, what are the advantages over, say, H1B? Is what they're asking.
The requirements are different. I mean, one of the benefits of L1 visa is that an applicant who has a viable business, a viable and legitimate business in his or her home country can actually set up a branch in the U.S. So, in other words, an applicant can be a self-petitioner if he or she has a viable, legitimate business in his or her home country. But H1B requires a sponsor. H1B requires an employer that can petition. Even though L1 too can also require an employer. If you are applying for L1B, you still need an employer. But there is opportunity for L1A, which is the directors of the company, the owner of the company. They can self-petition if they have a legitimate, viable business in their home country, which H1B cannot do. In addition, currently, because H1B is temporary employment, virtually everyone who went to school in the United States, or virtually every foreigner who went to school in the United States, upon graduation, always look for an employer to petition for them through H1B. So because of that, there is a lot of pressure on H1B, and annually the number of applicants always exceed the available spots provided by law. So because of that, it requires balloting. So it requires balloting, and I can say probably since 2005, this is 2023, that's almost that's about 18 years now. For the past 18 years, every year we have to ballot for H1B. So it's not even guaranteed. So even if you have an employer willing to petition for you, there is no guarantee that your petition can be selected. So because of the number of people that apply. So usually when H1B opens early in the year, within a few months or weeks, it closes because usually immigration will have received more applications than available spots. So that always leads to balloting. And in the last 2-3 years now, USCIS has mandated that every employer planning to apply for H1B must pre-register with USCIS. So it is that registration process now that they use for the H1B selection. So all this does not currently affect the L status. So what that means is that throughout the year, one can apply for L status. Whereas right now, you cannot apply for H1B status throughout the year, except if you fall into one of the exceptions for the CAP. And the exception for the CAP, maybe you work for a non-profit organization or you work for an educational institution. So those are some of the exceptions. So except to fall into the exception, H1B is not available throughout the year. It is only available at the beginning of the year. The employer must register and is not even guaranteed. So those are some of the benefits of L1 over H1B.
So is there a limit on the number of L1A visas that can be provided in a year? Because you mentioned that there's a cap on H1B visas. So is there that same limit?
Every single visa status, with the exception of immediate family, every single visa status has a limit, has a numerical limit. But again, for H1B, I believe the cap is 65,000 in a year. Then there is extra 20,000 for foreign students who obtain master's degree from an American university. But again, I can't remember the L number in my head right now. But again, from my experience, we have never finished the L status. We have never finished it, just like the R status. Those are status that has never been exhausted annually.
Okay. So what are the limitations of L1 visas?
Well, the only limitation is that you meet the requirement. So, like I said, if it's a new company, they want to be sure that you are doing what you told them you are coming to do. So they will only give you L approval for only 1 year. So if you don't do what you told them you are coming to do, when you apply for extension, it will not be approved. So you have to be able to do whatever you state in the petition that you are going to do. And of course, that is the only limitation that I'm aware of.
So you mentioned making sure that you're doing what you said you were going to do in the petition. Does someone like an officer from USCIS or anybody else, do they do some sort of site visit to the new branches, or is it mainly based on what's provided in the petition?
Well, right now, it is based on what is provided in the petition. But again, that does not mean that if there is a red flag, if there is reason. So remember, we are talking of foreigners here. So if any information comes to the attention of the government, any case, even including H1B, will be investigated if they have reasons, if there is a red flag. However, there is no statutory requirement for now for such investigation. The only non-immigrant category that has that statutory mandatory site visit is the religious visa.
Okay.
So that one, it is mandatory. There is no way around it. So it is mandatory. They must go to the site and verify and they can go pre-approval, they can go post-approval.
Mm-hmm.
So that is the only one that is mandated. So
Okay.
L1, there is no such mandatory site visit.
But it's
However,
possible.
again, if there is a red flag or there is reason, if there is anything that trigger investigation, even U.S. citizen can be investigated if there is reason for it.
Yeah, of course.
So
Okay. So somebody asked, who is responsible for paying the L1 visa at the embassy? Is it the employer or the employee?
well, the employer is responsible for paying for the petition, and that is everything that is done here. The employee is responsible for applying for visa. So if applying for visa requires payment, that would be the employee's responsibility. But the petition itself, it is the employer's responsibility to pay for the petition.
Okay.
Because the petition has to be filed and approved here before you even think of going to the embassy to apply for visa.
Okay. Someone asked, can an L1 visa be converted to an H1B?
As in change of status?
Yes.
Yes, it can. Yes, it can. Somebody can change from L to H. Yes. There's no restriction on change of status.
Okay. And then what about working remotely? With COVID, a lot of people have started working remotely. Is that possible on an L1 visa? If you're working for, say, the United States branch of a foreign company, is it possible to then work remotely for that United States branch?
Well, that is a very technical question. Remember that COVID is something that is new, so there is a lot of wiggle way around issues around COVID. But one thing I want to say is that a lot of the lapses created by COVID, immigration has started ending many of them.
Yes.
For example, the 60-day additional extension for response, it has ended. Now, a lot of immigration courts are requiring applicants to appear in court, not remotely. So a lot of COVID flexibilities are ending. So I don't see how they will approve remote employment for this purpose, especially especially if it is a new company. If it's an existing company, maybe yes. I mean, if we are talking of a company like Microsoft and all of that. But again, the challenge you are going to have is that if this employee can work remotely, what is the need to come to the U.S.? Why not just work remotely from his or her home country? So those are the challenges that people are going to face. But again, this is a novel area that has not been it's not a place that I've worked on before, so I cannot talk from experience. But I don't know how immigration will handle it. But using my own personal experience and knowledge, if I am the adjudicator, if I will ask that question, if you are going to work remotely, then what is the need to come to the U.S.? Why not just work remotely from your home country?
Okay. Then earlier you spoke about how there is a path for permanent residence when you start out on an L1 visa. How soon after someone has been on L1 can you start that process of adjusting your status?
Well, it depends. It depends on the kind of L1. If it is a startup business, like I said, it will be approved for initial 1 year. So you have to show after that 1 year to apply for an extension, you have to show that the company is viable. So if you provide evidence that the company is viable and all that, the L1 will be extended for another 2 years. Then Upon that 2 years, you can now start the process of permanent resident, because by that time you will have established that the company is viable. But if it is an employee like L1B, then again, depending on if the company has it depends on how stable the company is, how viable the company is, because an employee, in their own case, the initial approval is valid for 3 years. So after the first 2 years, out of that 3, they can start the process.
Okay. And then someone has also asked, can I start a business on an L1 visa? So I'm assuming they mean someone who's here on an L1 visa, can they start their own business then?
Well, it depends on the nature of the business, because you don't want to violate. If you are approved to work for a specific company, especially in a non-immigrant status, they expect you to work for that company. So if you start your own business, except if you are planning to switch your L to that new business, it may be a tough one. I really don't know the accurate answer to that, because like I said, this is not something that I have considered before, but I believe that it will be a dangerous path if you start.
Because you said that you have to be working full time for the company that you're working for.
Yes.
So it would be hard to prove.
But it may not be as fatal as religious, because what makes religious visa different is that, one, religious employment are exempt from the process of labor certification, and the U.S. government does not appreciate people abusing that privilege.
No, they don't.
They are not required. They are not required to offer the position to American citizens first. So all the requirements of labor certification are waived for religious employers. So they don't like it when people abuse it. And secondly, and the most important, the law that created this thing, that created the religious employment, that law used the word solely, S-O-L-E-L-Y, solely. Solely means that you cannot do something else. If you say you are a pastor, that is what you have to do for those periods that you are working for the employer. So the moment you do something else, it is considered a violation. However, the law that created L status did not use that word.
Okay.
It did not use that word solely. But at the same time, they still expect you to work for the employer that petitioned for you. They expect you to comply with everything that you state in your petition that you are going to do.
Yeah. I mean, that makes sense.
And for H1B, for example, H1B actually allow an employee to work for multiple employers. H1B allows that. The only thing is that you must disclose it. You must disclose it. That, okay, you are going to work for the law office of Olu Asekun. You are also going to work for George Anibowe. So you must disclose it. It cannot be something that they found out on their own.
Yeah. And also, just to add in, like you say, immigration is not a one cap fits all. I know you always say that. I mean, every situation is different. That's why it's really important to consult with an immigration attorney anytime that you're filing any type of petition or application. It's always best to consult because every situation is so different.
Correct.
So I believe that we have answered all of the questions that we have, and it's actually it is 1 p.m. right now. So
okay, so I want to encourage listeners. This is a free service that we do every Wednesday, 12 p.m. Central Standard Time, 1 p.m. Eastern Time, 10 a.m. Pacific Time, 6 p.m. Nigerian Time. Remember to invite your family and friends to benefit. It will be unfair for you to benefit from all this massive information without sharing with others. So invite your family and friends. Join us next week, and also remember to subscribe to our channel so that you'll be notified whenever we go live.
And follow us on TikTok.
Yes, thank you so much again, Kimberly, for standing in the gap for me.
Oh, you're
like
welcome.
I said, I'm on family engagement. I had to come to my daughter's college, so that is where I am right now, and that is why I'm not able to come on live video. So thank you again for standing in for me, and I believe you can take it from there.
Okay, thank you. Have a great day.
You do the same.
Thank you. Okay, so thank you all for tuning in. We are rounding up for today. Today we talked about L visas. So as Dr. Asekun was saying, please make sure to subscribe to our channel, follow us on TikTok, on Instagram, on Facebook. We're starting to post more videos, and we'll be posting shorter videos as well that touch on just, smaller points that we do in this podcast. So thank you so much for joining in, and we will see you next week.
Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family, and call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I announced, I'm coming to your office. He said, okay, but just drive carefully and things like that. So, okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through in it. Like I mentioned, like we all handle their case, we all know their cases. And it's like I am one of them and I understand what's going on. And I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in her face and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own. And we all celebrated. It was a good thing.